Welcome, class. By now, most of you would have seen and understood the substantive content of intellectual property rights. For instance, what is a patent? What is copyright? What is trademark? What are the limitations on each of these rights? And so on and so forth. But it's one thing to understand the law from its substantive point of view, as in what the content of the law is, and quite another to understand the ways in which one can enforce these various rights conferred by the law. How do you enforce a copyright? Suppose you have a patent in respect of an interesting technology. How do you stop somebody from infringing on your patent? In law, what are the different remedies that you have? What do you ask a judge, in other words, and in simple terms, as to what you need to protect yourself and your interests? So in this module, we are going to look at 4 important kinds of relief that the law guarantees and the different ways in which these reliefs operate to protect the plaintiff. The plaintiff here is the person who sues to enforce his intellectual property rights. What are these 4 important remedies? The first is, of course, injunctions. Then there are damages and exemplary damages. And then there are ante and pillar orders. And of course, there is rendition of accounts as well. So these are broad remedies that the law uses to protect your intellectual property rights. Why are these remedies important apart from the simple practical question of how do you enforce your rights? From a conceptual standpoint, these remedies are also important because they give us a strong insight into the kind of right that property is, or intellectual property is. Finally, the key word here is property when you talk of intellectual property rights. So, when within the structure of property there is violation of a right, what the law seeks to do is simply, in some sense, to bring about corrective justice. So there is an equilibrium, and that equilibrium has been violated by the act of infringement. What the law does is restore the parties to the position in which they would have been had that equilibrium been maintained, and this is corrective justice. So through these different remedies, we also get a sense of the structure of substantive intellectual property law from a conceptual perspective. What does it mean to have a right? And what does it mean when somebody is said to violate that particular right? What is this equilibrium that we are speaking about? So these are also questions to which we find answers through this whole process of looking at the different remedies that intellectual property law accommodates. So diving straight into the first of these remedies, and clearly the most important in terms of its effect, in terms of what it can achieve for the parties, let us start with injunctions. Now, injunctions are nothing but a restraint or a direction. So they can either be a restraint, in which case they are prohibitory in content, or they can be a direction to do a positive act, in which case they are known as mandatory injunctions. Again, injunctions are granted both at the interim stage of the proceeding and as a matter of final relief. This requires a little bit of explanation, and which is what we are going to look into for the next couple of minutes. So, let us just use a hypothetical. A is a film producer. He has produced a film title X. B, without taking A's permission, remakes film X in another language. Now the script in film X also has been assigned to A. So owner is A as far as both the script and the film are concerned. A files a suit against B. Now B's film, let's call it Z or Z, is currently under production. In fact, it's finished, completed the production and is in the post-production stage and is out for release in the next couple of weeks. But the trailers and the promotional material of the film is out. Watching all of that, A is certain that B has basically remade X and created Z. Now what does A do? Of course, A can file a civil suit, and that's what in most of these cases happen, at least at the level of civil remedies. So fine, A does file a suit. Now what does A ask? Obviously Z has not released yet. So there is no financial loss that A has suffered for the moment. Except of course the loss that he would suffer simply because nobody else is going to acquire the remake rights for X in that particular language in which Z is being made. But more than that, A's huge concern is with the release of the film Z, because once Z comes out, that's when he's going to suffer this loss, the real financial loss that nobody else is going to take remake rights in respect of that film. Now, we all know that a civil case can typically go on between an average of 6 to 10 years. So what A seeks in the case as a matter of final relief is something that he is only likely to get somewhere between 6 to 10 years from the date of filing the suit. But is that what he wants? No, he wants to stop the release of Z immediately. So what does he do? He applies in the suit by way of an interim application and seeks for what is called an interim injunction or a temporary injunction. So this is something granted during the pendency of the suit. So by the very nature of interim reliefs, they are granted at some point between the date of initiation of the suit and the date of final disposal. Now these interim reliefs can be of various kinds, but the most important is that of interim injunction in the context of intellectual property rights especially. We also need to keep in mind the simple fact that with intellectual property rights, the shelf life of the right is very limited. Yes, it's true that the duration of the right is pretty long, especially in the case of copyright. You could say life of the author plus 60 years. But let us look at most content today. For how long do the public have an interest in a book? For how long do they retain interest in a film? So, as a matter of time, intellectual property rights have limited shelf life. As a matter of monetary value, again, customer preferences or consumer preferences change. You make a movie that is suited for the time and the occasion now. In another 20 years, if it's a classic, yes, there will be people watching it, but if not, nobody will care. You make your money and you move on. The same applies to a book. Same applies to computer software. So most content today that we have is dated by virtue of limited customer attention span. So can you wait for 7 or 10 years to really stop somebody from remaking your film? When the consumer interest in your film is current, and in another 10 years trends may change and there won't be any takers for your film. So considering all this, interim injunctions become very important, even more important in the case of intellectual property rights, I would say, than with other areas of substantive law. Now, in interim injunctions, as mentioned earlier, there are both prohibitory and mandatory injunctions, and we are going to look at both. But before we get into that, an important clarification is in order. When it comes to the substantive law governing permanent injunctions, we have to turn to the Specific Relief Act. But on the other hand, when it comes to the substantive law governing temporary injunctions, it is governed by the Code of Civil Procedure. So the Code of Civil Procedure is what we will look at first, and then we will proceed to the Specific Relief Act and final injunctions. Though the law, in terms of the factors the court has to keep in mind while granting the injunction, remain almost the same, both with temporary and permanent injunctions. So permanent injunctions are the ones that are granted at the end of the suit after trial, which is a final relief, and interim injunctions are by way of interim relief. So what are the different factors that the court has to keep in mind while granting interim injunction? That's the first point of concern for us.